I'm Aaron Weller. I'm co-founder and VP of strategy for Sentinel, which is a privacy consultancy and technology company based out of Seattle, Washington. It's around 5 a.m. here, so forgive my coffee habit as I go through these slides. What I'm going to talk about today is really the how to future-proof your privacy program. So I've spent over 20 years consulting to Fortune 500 organizations around the world. One of the things that I've seen again and again is that organizations react to changes to events and end up putting themselves onto a tight timeline to comply with a new set of requirements. This presentation gives an overview of an approach that I've developed over the last few years that I've been using to help organizations think differently about the role of their privacy program and how it can help to balance a number of factors that go beyond legal compliance to deliver better outcomes for a range of stakeholders. I think of this as developing a culture rather than focusing on compliance. But I don't mean culture in kind of a touchy-feely, all hold hands in a social distancing way kind of thing. I mean understanding and aligning different perspectives to drive a shared vision and shared outcomes. Let's get real. This is a pretty common view of personal information that I run into in the US very frequently, and in other places as well. Not only is personal information seen often as a big bag of money, but in many cases, it does seem to be there for the taking. People across organizations use personal data for a variety of purposes, often without really thinking about what the constraints are on how they should use that. I think of personal information usage as really a horizontal problem in organizations that are structured vertically. Almost everyone wants to get their hands on the money, and it can be hard when you've got different parts of the organization that have different reasons for using that personal data. One of the big challenges that I see is that if you see data this way, most privacy programs have the effect of standing between you and the money, the data that you want to be using in the way that you want to be using that. And that's really not a good look for privacy programs. That's really where when privacy programs are focused just on legal compliance, this is often the perception that you're getting in the rest of the organization. But I do think there's more to it than that. For balance, of course, here's the other end of the spectrum. Here's another view of personal data. That privacy is really a human right. And this particular quote comes from the Universal Declaration of Human Rights. No one should be subjected to arbitrary interference with his privacy, family, home, or correspondence. So with that, how do you reconcile those two very different views of personal information? One that's very much a privacy-centric view, and the other is more of what people would tell me is a business reality, where the personal information drives business goals and objectives. And we need to be thinking about creative ways to be using it to do different things, to innovate, and ultimately to make more money. So one of the challenges is that these two views aren't necessarily equal in any particular circumstance. It might be that in some cases, one side is more impactful, but in other cases, it could be that the privacy risks really outweigh the benefits of doing something. So how do we help organizations, or if you're in an organization running a privacy program, how do you think about finding the right balance between these two different perspectives? So really the challenge that I've seen and that I try and help organizations manage through is how do privacy professionals build programs that take both of these views into account at the same time, and hopefully without suffering from too much in the way of cognitive dissonance. So what my suggestion is to redefine, and in redefining future-proof, the role of a privacy program by looking more broadly at the management of personal data and the constraints on what can be done with that personal data. Some of you may be familiar with the theory of constraints, which is a book that I read a long time ago, and has really influenced my thinking on how do we really look a little bit more broadly than just, whatever the next law is coming down the track. So if we think of privacy as managing data constraints, how could that help us reach a different outcome for our privacy program? And I will put it to you that it does, but if that's true, then what kinds of constraints make sense to manage? And I'm not trying at this point to say that the privacy program should be the be all and end all, and really the only part of the organization that's helping to manage personal information, because I don't think that makes sense either. But I do think we can have a constructive discussion by thinking a little bit broader than just one factor. So if we think about a typical data set, what are the kinds of things that stop us doing whatever we want with this data? I would put it to you that there's really a range of different things that could stop us. One of them is clearly legal requirements. So looking at what are the laws that say, you can't collect this data without consent, you can't collect this data in this way or use it for this purpose. But it goes beyond that as well. One of the other things that we should be considering is what are the contractual restrictions that we may have over data, particularly if your organization is more of a data processor that takes information from other organizations and then uses that to perform services, a variety of functions. You may find that I've seen this with some of my clients that the contracts are actually more important than the laws. The reason for that would be that your major suppliers are probably much more likely to audit your compliance with the contracts than a regulator may be to come and look at your compliance with laws. So beyond contracts, you then get into some of the other areas that are a little bit harder to define. Data ethics is something that I've seen a lot more talk about in the last couple of years, where really what I mean by data ethics is when you have an opportunity to look at whether we can do something with information, it's then the question about whether we really should. And this is usually where I channel Jeff Goldblum in the first Jurassic Park movie. Your scientists were so preoccupied with what they could do, they didn't stop to think if they should. And I think that's really where data ethics can be a valuable consideration when we're looking at, particularly when we're looking at innovative new uses of data and thinking about whether something that potentially is not illegal is really the right thing to be doing. Even beyond that, we're then looking at what are our customer preferences as well? What do our customers really say and what do they feel about the ways that we are using their personal information? Do they think that we're being transparent? Do they think that we're actually collecting the right amount of information for what we need to do? Do they feel that they have choices around how we use that personal information? Or is it really all or nothing? So again, something that's a little bit harder to define, and certainly not, if you're in some of the previous sessions, nowhere near as defined as like an ISO standard, but something that I still feel is really important and often underlooked and undervalued when people are building and managing privacy programs. And then the last, but definitely not the least, constraint on how organizations can think about privacy is their overall business strategy. If you work from an ad tech firm and really your business is making money out of personal information, you're going to be hard pressed as a privacy professional to really drive a lot of those restrictions without really being considerate of, how do we find that right balance between enabling the business strategy and complying with some of the other things that we may have to do. So really, again, it's business strategy is something that is a factor on how you can or will use information. And I don't just mean that means that you should relax the restrictions. Business strategy could be the other way around as well. Let's say, for example, in the US, we had the California Consumer Privacy Act came into effect earlier this year. It only applies to residents of California. However, some organizations that I work with have taken a strategic decision to say, we should be providing those rights and those privileges to not just California residents, but across the rest of the states that don't have an equivalent law. That's a strategy as well that also shapes the way that your privacy program operates. It means you're going beyond that minimum baseline of what the law says and really thinking about how can you differentiate yourself. So in combination, these 5 factors are what I call a culture of privacy. And it's really something that when I'm talking about culture, as I said, I don't mean it in that kind of training and awareness and we should all have a shared culture kind of way. It's more about thinking, how do we get organizations to look at personal information management as being something that consists of a multitude of factors that go beyond just the black and white letter of the law and give us a broader perspective on finding the right balance when we're taking into account different stakeholder views. It's important to realize, and it's probably fairly obvious, that different stakeholder groups will have different priorities amongst these 5 areas. For example, if you're looking at executives, often they find that, and you should find that strategic goals are really their priority. thinking about keeping out of trouble from a legal perspective is often likely important as well. Sorry, I see people having issues with the size of the slide. So Susan, please let me know if that worked and made that a little bit bigger. So you're going to find that different groups of people around the organization are going to have different views and priorities of where these factors have importance. Product teams may be very customer centric, but really they don't see it as their job to manage legal compliance. But then if you're going to be going and talking to a legal team, you may find that they have, or you probably will find, that they have a much higher focus on legal compliance, but not necessarily as much of a focus on really keeping the needs of the customer at the forefront of what they're looking at. So when I'm thinking about this, really looking for what I'm trying to help organizations do, and what I'd suggest that you can take away and think about in your organization, is how do we get to a combined view of these different stakeholder groups that really drives to a shared vision, shared culture, and really shared values around how do we think about personal information. It doesn't mean that you're going to find one place on the balance that is always correct or always the right choice in every single scenario. But by thinking about it this way and having that common language of describing what happens with information privacy, we can find that we can have a very different conversation from when you go in and you say to the chief marketing officer, well, you shouldn't have done that, and this is why the law says that you can't do what you're trying to do. So my perspective is that by taking into account these multiple factors, we can help to find a balance for any particular scenario. And again, you know that or you've probably heard before, that the way to make pretty much everyone unhappy is to try and please everyone all of the time. Really, what I would be advocating for is what we're looking for is to keep the majority of people happy. And we know that there are always going to be people who will find something to be unhappy about. And there are also some people who won't complain no matter what you do with their personal information. What I try and do and suggest to my clients is that let's try and find that middle ground. Let's plan for the people who will complain about our privacy practices and make sure that we've got a good story to tell. Because one of the really important things with metrics and measurement is it almost doesn't matter how good your metrics are unless you've got that good story wrapped around it about what you're doing. And I think things like your privacy notice are an important part of that story, but also other factors like your complaint handling process. How quickly can you help someone understand if they have a question about your privacy practices? What are you doing about them, and how are you using their data? Again, some of this stuff is not mandated in the law, but it really is something that as you're building a broader privacy program, you should be strongly considering. So that all sounds great, but I'm sure it sounds very theoretical as well. What I'm going to go through now is a couple of real examples of where I've used this approach in some organizations. I work with, as I said, a number of Fortune 500 companies and some smaller organizations as well. And where we've used this case, I'm going to give you a micro example and then a macro example of how you can use this approach. And then I'm going to give you some additional resources with some other articles that my team has written around taking some of this approach a little bit more broadly. So let's talk a little bit about an enhanced balancing test. So I'm assuming most of you are based in the UK. You can probably tell from my accent that at one point I was in the UK. I even used to say privacy, but I left the UK in 2003, lived in Australia for a while, and have been in the States, first in Silicon Valley and now up in Seattle for the last 15 years. But one of the things that I was heavily involved in over the last couple of years was getting US-based organizations ready for GDPR. One of the things, if you're familiar with GDPR, you'll know that Article 6 describes 6 ways that you can actually achieve legal processing of personal information. Article 6F is legitimate interest, where an organization has to balance the risks to the rights and freedoms of individuals with the benefits that they see out of a kind of processing activity. If the balancing test balances, so for example, if the controls that you're putting in place to manage those risks are considered to be adequate and balancing the risks of that processing, then you're allowed to perform that activity. And my team has done a lot of legitimate interest assessments over the last couple of years. And really, if you're familiar with that process, you think about first you're describing what is it that we want to do with the information? So what is that legitimate interest? You're then looking at what are the risks, and then you're doing a balancing test between those two different areas. What I would put to you is that that structure provides a good baseline for them thinking about in a particular use case. So, for example, if we're doing a privacy impact assessment on a new type of processing activity, you can think about it expanding your existing questions to take into account, how is the customer going to feel about this potential use case? Would we see any ethical concerns around doing this kind of processing? Would we really think that this processing is in alignment with our broader business strategy? Is there a cost of not doing this, and how should we take that cost into account? You may have seen the recent guidance that came out around the interpretation of how cookie banners should work. And some of those potential changes, like not being able to click away from the cookie banner and have that considered to be accepting it, can have a multi-million-dollar impact on organizations that are very reliant on advertising revenue derived from the processing supported by those cookies. So to really be 100% legal compliance may often be missing the bigger picture. And it can be a much different conversation when you're talking to other executives who are really focused on some of those other areas of the culture wheel, if you're not really thinking about and taking into account some of those considerations. None of this means that complying with the law is not important. All I'm really doing is saying that you can take that and you can expand your view and really take a broader perspective on thinking about how do we describe personal information in a way that's more inclusive and taking into account different points of view. So you can consider doing a culture of privacy assessment as really an enhanced legitimate interest assessment. And even if your legal basis is not legitimate interest for what you're trying to do, you can still think of that concept in a similar way. But for me, the more exciting use case is really the macro use case. It's being able to redefine your privacy program to consider all of these different kinds of constraints and to manage them in a consistent way. One of the real challenges with this is that some of these areas, particularly legal, are very well defined in comparison to some of the others. Even from a contractual perspective, I'm not really familiar with many organizations that take their contracts and actually look at those and manage them on an ongoing basis, right? There's a lot of work that's done up front to make sure the right contractual language is in place. Some larger organizations may even do rotating audits of some of their contracts to make sure that the terms are being complied with. But oftentimes, and in fact, the vast majority of the cases, you're not really getting into managing those contractual constraints as part of a privacy program. They seem to be almost very separate, managed by the procurement function or another part of the organization. But when these contracts may say things like, you can't move this data across borders, you can't do certain other things with processing, you can't combine it with other data sets. I've seen many examples where organizations have gone significantly wrong because they weren't actively managing some of those contractual commitments. And even with some of the other areas as well, it's important to think that ethics is not just the stuff that's really nice to have. Increasingly, ethics is becoming talked about as part of privacy programs more generally, and really getting away from seeing it as being, again, very, very subjective. And people are trying to define data ethics frameworks so we can be a little bit more thoughtful around how we're applying ethics to some of the other stuff that we do. To be able to do this properly does require significant definition of those less well-defined areas, and also normalization so that you can be having a consistent conversation no matter which of those factors are influencing what you're trying to do. And that's really where I've been focused for the last couple of years, and where my team has been trying to do some of this research and really get towards better definitions so that we can have these conversations in a more constructive way. Here's some additional resources if you're interested in kind of this approach and you want to get into some further reading. My team is in the middle of publishing, we've currently published 4 of these 6-part articles on how to build a culture of privacy. So beyond kind of my high-level slides, we've got several thousand words on each of these segments and kind of thinking about how could you incorporate them into an overall privacy program. One of the other things that I've been doing is building a technology platform, which we call Ethos. Ethos is based on this same approach, and the IAPP actually just did a write-up last week of kind of how our platform looks a little bit differently at building the right privacy program for your organization. If you're interested, I'll be giving a demo in about an hour's time, assuming that I can wake up again after this coffee. But with that, if there are any questions, I am more than happy to take them now. I will be around for the next couple of hours, and I hope you found that interesting. It's been something that's been interesting to go through and build, and certainly the reception that I've had with the organizations I've worked with, it's very interesting when you see that people can start to say, oh, I can take a little bit different bit of a point of view on this, and hopefully there's enough information here in the additional resources that you can maybe start thinking a little bit differently about your privacy programs as well.